One of the most pressing things that comes into my office that I deal with on a day-to-day basis is that landlord who comes to me and says, Ernie, all I want is to get my property back. I know they owe me rent. I know they've caused damage, but if I could just get my house back, I would be so much better off. Today, we're talking all about that. Let's get started. Now, over the years of me representing landlords and property managers and property investors in landlord-tenant matters having to do with residential and commercial tenancies, I've learned quite a bit about what it takes to get property back faster. There are certain things that an attorney can do that maybe the landlord by themselves hasn't quite mastered. Maybe you haven't seen enough of these occasions to really know. I'm hoping you can learn from me and my years of experience resolving these kinds of cases probably faster than a landlord can do it by themselves. The first thing we think about when we're trying to recover property is the eviction process. And sure enough, that is an effective tool and it's probably the most effective. But how you utilize eviction is itself important because there's no one-size-fits-all approach, even when you utilize the eviction process. So I'm going to break down pre-eviction, during the eviction, and even toward the end of the eviction, steps that you can take that are going to speed up the process and make it more likely that you're going to recover your property faster. So naturally, the best eviction is the one you never ever have to file. If you can take steps before a problem starts to prevent that problem, you're going to save yourself time and money. And so one way to do this is to have a rock solid lease. If you don't know whether your lease is rock solid or not, or you're pretty sure it's got some problems, you're going to want to talk to somebody. You're probably going to want to reach out to a real estate attorney and make sure that your lease gets reviewed or that it gets scrapped and you start over with a rock solid lease. Along with that lease, you're going to want to have a set of house rules that apply specifically to your property, how it's to be maintained, and how you want it cared for throughout the tenancy. House rules along with a strong lease make for a really great start to any tenancy. Now, having your rules in place in writing is crucial for you to later be able to enforce them, but even more so before you hand over those keys, I strongly recommend to all landlords that they should sit down and talk with the tenant prior to delivering possession of the property. And part of that talk should include how you handle defaults. Point to the lease, talk about things like eviction and notices, default, notices to vacate, notices of termination. All of these things are important to get out in the open. It might be a little bit uncomfortable, but it doesn't have to be. You can talk about it in a way that you say, look, this is the way I approach it. This is our system. These are our company policies. Whatever makes you comfortable talking about the potential for defaults. Because the reason you're talking about this is because you're hoping to avoid them altogether. But you do want that tenant to know that if things get out of line, that you will be issuing notice. And so that's where step 3 of this procedure comes in, you writing out notices and being ready to do that. If you start a tenancy and your tenant defaults and defaults and defaults and you've never given out a written notice, you are essentially condoning that bad behavior. You want to be able to stop that right from the start. In fact, you're talking about it before it ever happens, and if and when it does, you're issuing immediate notice so that your tenant knows. Remember that thing we spoke about before I handed over the keys? This is what I mean. I'm building a case. Here's your first notice. Hopefully we don't see another one. By shifting the responsibility to your tenant to make sure they stay in line in order to stay in place, you're going to likely prevent them from holding your property hostage and therefore never putting you in a position to need to recover it from them. Now, one thing you can do for me that I would greatly appreciate is to hit that like button, maybe give us a comment or send us a question. I answer those personally, and if you haven't subscribed yet, please consider subscribing. We continually appreciate your support of this channel. However, sometimes violations do escalate and the need to file an eviction comes up, and so you're going to be happy that you started the process sooner rather than later, because the same is true with filing that eviction. Sometimes landlords tell me, well, Ernie, I think I want to wait and see. But the truth is there's a lot of waiting already built into the eviction system. I would recommend that if your tenant has already gotten to the point where you're issuing a notice to vacate, there's no good reason for you to wait. Once you can file, you should. For landlords who wait another week or 2 or 3 or months even before filing, you come to learn that the process itself takes about 30 to 45 days. That's potentially 2 full months of non-payment on top of the amount of time while you were waiting to see if your tenant was going to turn things around. If instead you issue a notice to vacate and file as soon as you can, you're going to find that your wait and see period happens simultaneously with the trial process and the time you're going to have to wait to get in front of the judge. And if it turns out that your tenant does turn things around, you can always pull that eviction back. Unfortunately, you can't just make up the time if you've waited and waited and waited and the tenant still hasn't come through, and then you're waiting again throughout the eviction process. If you can do it now, do it now. Now, certainly if you do file, you're going to want to file it properly. That includes sending proper notice. Your notice to vacate is step 1 of your eviction process. You want to make sure that you get it right, both in what it says and in how you deliver it. If you are unsure how to deliver or how to draft a proper notice to vacate, again, seek out someone with experience, seek out a real estate attorney. We are happy to help any way we can, but make sure that that notice to vacate is submitted and delivered and drafted properly. Nothing is going to wreck an eviction like bad notice. Like with any civil claim that you file with the court, you're going to want to make sure that you have compiled the best evidence. Don't show up to the eviction court with purely anecdotal evidence. Have records. If it's a matter of non-payment, make sure you have a receipt book, an account ledger. Make sure that if it has to do with something other than non-payment, that you have those notices that you've issued every single time where you've given your tenant an opportunity, a reasonable amount of time, and you just haven't seen any change from them. If you have a 3 strikes and you're out policy and you've given 3 or 4 attempts for that tenant to cure whatever that defect is and they still haven't done it, that goes a long way to establishing for the court your right to possession. And of course, you're going to want to make sure that you present all of your claims, particularly your strongest claim. I'll tell you that hands down, the best claim for recovery of possession in an eviction is a non-payment of rent claim. So that if you're presenting your case and the only thing you're really worried about is possession, don't just drop certain claims because you don't think they're necessary. Always include all of the claims in your notice to vacate and all of those claims in your eviction petition, because you never know which one of them the court is going to say you have insufficient evidence for. By stating all of them, you're the likeliest to recover possession as you first intend. Now, naturally, when you think of an eviction, you think of a final judgment and a written order from the court giving you the right to go and clear everybody out along with their property. But that's not the way every eviction ends. And so if you can find a faster way of recovering your property through the eviction process, it might be one of these. If you haven't tried these, I recommend that you at least consider one of the following. Naturally, when you're in the middle of eviction, you are looking very forward to its end, but there's a few things you're going to want to consider to expedite things and to be prepared for, because they don't all end the same way. Namely, you're going to want to prepare for an appeal. You always want to act with the appeal in mind. That's one of the main reasons you want to establish non-payment of rent, because on appeal, in certain states, certainly in the state of Texas, a tenant who is being evicted for non-payment is required to pay rent into the court's registry. If you drop your rent claim for some reason, they may not have to do that to appeal, and that appeal may go on for free for a number of months. Whereas if rent is required specifically to be paid into the court's registry during the pendency of an appeal, at least you're recovering something from the tenant while that appeal proceeds. Additionally, whether you're in the first court or maybe the second court because your tenant appealed their case, you should always be prepared to settle. One thing that I find is a lot of hostility from a landlord when the eviction process has begun. And they'll say things like, no, I'm not going to budge 1 inch. But you may find that by giving time to your tenant, you actually gain time in recovery of the property. And it's simple math. If you can get that property 1 month sooner, that's an entire month of rent you've just saved. And so If you have the opportunity to enter into an agreement with a tenant that will expedite the process, you know that if we wait for judgment, it's going to take 60 days, but if they can get out in 15 days, that's going to work out better for you. That 45-day extension would hurt more than it might hurt to just give them a little extra time for free. Understand what the rules say, understand what you're dealing with in terms of time, and you might be able to settle and get your property back faster. When you are settling, I always suggest you get that settlement down in writing. In Texas, we refer to this as a Rule 11 agreement. It's an agreement between the parties that can be filed with the court. And in it, you could say all sorts of things. In fact, that agreement might even have payment from the defendant as rent. And it may be that that payment simply buys them additional time. For example, if a tenant says, look, I want to get to the end of the month, and you say, well, that's 3 weeks away. If you'll pay a full month of rent, even though I know you owe 3 months, if you'll pay me 1 month of rent, I'll agree to give you until the end of the month. And then you might consider even dismissing the case as part of your exchange with them. In exchange for speed, in exchange for time, you're giving a little bit. You're getting a little bit of rent, you're giving up a little bit of your judgment, but you're getting the property back faster. Again, if you're in a situation like this and you need counsel to really guide you through and talk about how long these things generally last, it's always helpful for you to reach out and talk to an attorney in your jurisdiction. Now, of course, and I've seen this happen so many times, don't simply rely on an unenforceable promise. Too many times in the middle of the process, a tenant will say something like, well, I'll go ahead and move if you drop the lawsuit against me. The landlord drops it, and wouldn't you know, the tenant doesn't actually move, and the landlord has to refile the whole thing. Make sure that you are dropping the lawsuit, if at all, in exchange for something concrete. You have keys in your hand and a vacant unit, or you have money in your hand. And make sure that if you take money and you're going to keep that tenant, that it's worth it for you to keep that tenant. Make sure that you're not just kicking the can down the road and you're eventually going to evict them anyway. You're going to want to bring everything to full resolution, but you're definitely going to want to get something in exchange for dropping your eviction petition. I know that the courts can be scary. I know that it can be complicated if you just don't have a whole lot of experience with the courts. I strongly encourage you to team up. Find yourself a mentor, someone who's done this a few times. Find yourself a good real estate attorney, someone who's taken many of these cases to trial and been effective for their clients, because you're going to get some good advice. In fact, if you get it early on in the process, you may end up sparing yourself multiple months of lost revenue because you acted differently than maybe you first planned to. When you get this advice, it's going to help to limit the amount of time that you are without your property, because the most valuable asset you have is that rental property. Anything that somebody like I can do to put it back in your hands faster means more money in your pocket. For more content just like this throughout our channel, YouTube seems to think that this particular one is a good video for you, but we've got tons of content here for you to enjoy. I thank you for watching, and until next time, happy leasing.